In Burwell versus Hobby Lobby, the Supreme Court ruled 5-4 that the Obamacare contraceptive mandate could not be enforced against a closely held corporation whose owners object on religious grounds to funding 4 of the list of 20 contraceptives that Obamacare requires. Now, this is actually not in the statutory text of the Affordable Care Act. This is a regulation that Health and Human Services passed interpreting the requirements, the mandates of Obamacare to put in a list of 20 different contraceptives that have to be covered on every employee's insurance plan as a part of Obamacare's employer mandate. And these 4, there are 2 intrauterine devices, IUDs, and 2 morning after pills. And these people object to them on religious grounds. And the court considered this not under First Amendment grounds, freedom of religious exercise, but under the Religious Freedom Restoration Act, which is a 1993 statute passed unanimously in the House, 97-3 in the Senate, signed by President Clinton, that says that the government cannot substantially burden people's exercise of religious liberty, except if it has a compelling reason to do so and exercises the most narrowly tailored means, least restrictive means, in effecting that goal. And here the court found that the contraceptive mandate was not the least restrictive means of providing free or subsidized or cost-free contraceptives to the employees of this particular employer. The court discussed how closely held corporations, at least, certainly can exercise religion because it's their owners, their controllers, the families that run them. They feel their religious liberty being violated quite directly by this mandate, or they have to pay astronomical fines. I think for Hobby Lobby it would be on the order of $1.4 million per day. And that's it. This was not a weighing of the rights of religious individuals versus those who want to access contraceptives. This was not a First Amendment disquisition on how generally applicable laws can or cannot burden religion. This was a direct, point-by-point application of a rather straightforward rubric that was put in place under RFRA, and that's it. And the way that RFRA is designed, the next type of religious objection that comes along will be evaluated on its own terms. This is not a grand, sweeping decision about the Constitution or the scope of religious freedom or anything like that. So we'll see. For transfusions, for vaccinations, the court would simply have to see, is there another way for, say, getting people vaccinated than to require vaccinations? The key takeaway here is that the rubric for the Religious Freedom Restoration Act, the way to interpret religious claims, isn't that religion trumps everything else. It's that once a claim is made, a court determines whether indeed what the government's doing is a substantial burden, and then whether nevertheless it has a compelling interest and tailors its program in a way that furthers that interest.